All right, we can go ahead and get started. Welcome everyone. My name is Nathan Silverstein. I'm the founder and president of the Polish Club at the University of Texas at Austin. This event is being recorded and will be posted on the Polish Club's website, where we have a virtual library of recordings of all our past guest speakers. Today's event is being hosted by the Polish Club at UT, a registered student organization. This is not an event sponsored by the University of Texas at Austin. The views expressed today are of the invited guest speaker and do not represent the views of the student organization, the university, or its officers. I would like to thank our co-sponsors, UT Center for Russian, East European, and Eurasian Studies, the Center for European Studies, Liberal Arts Honors, Texas Global, the Department of Government, the Department of International Relations and Government, and the Strauss Center. I'm excited to introduce today's speaker, Poland's preeminent constitutional scholar, former visiting professor at Yale, NYU, and other excellent law schools, current professor at the University of Warsaw and the University of Sydney, author and political activist, Dr. Wojciech Sadurski. Professor Sadurski is from Warsaw, Poland. He has written many books, including Constitutionalism and the Enlargement of Europe, Poland's Constitutional Breakdown, and his most recent book that came out last year, A Pandemic of Populists. He has been an outspoken critic of the current Polish government. In turn, the Polish government has filed numerous defamation suits against him. Professor Sadurski has claimed the suits are politically motivated, a form of harassment, and an attempt to infringe upon his freedom of speech. In response to the Polish government's suits against Professor Sadurski, hundreds of law professors signed a letter in support of him. Today, Professor Sadurski will be delivering a 20-minute speech entitled A Pandemic of Populists. Professor Sadurski will then take moderated Q&A for around 30 minutes. I have selected the most interesting questions from the audience and will ask them anonymously. It is my great honor to now welcome a leading Polish intellectual, Professor Wojciech Sadurski.
Thank you very much, Mr. Silverstein. My very big thanks go to University of Texas Polish Club and to all members of the audience who decided to spend this hour on a Saturday morning to discuss with me the issues of populism, in particular in Poland. And I would like in particular to acknowledge the presence of Professor Kurt Weiland, whose work on populism worldwide, with special emphasis on Latin America, has inspired me a great deal, and from whom I have borrowed the concept of discriminatory legalism, among other things. Now, I would like to begin not with Poland and not with actually a case study related to case studies discussed in my book, which I should maybe mention: two European countries, Poland and Hungary, two Asian countries, India and the Philippines, and two Latin American countries, Brazil and Venezuela. I will mention a seventh country, which does not figure in my book, namely Israel, because these days we are all in awe and admiration for the civil society's action in Israel against this sort of anti-rule of law actions of the executive, which resemble those actions taken in the other six countries discussed in my book. And when one thinks about the way that the populist script spreads around the world these days, let me just mention an event which may have escaped your attention. Just a few days ago, Polish Minister for Foreign Affairs, in fact, Polish Deputy Minister for Foreign Affairs, publicly announced that there had been going on in recent days conversations, he called it consultations, between Polish and Israeli government, and the Israeli government consulted, quote unquote, Polish government about, again, quote unquote, the judicial reforms. So here you have a case of a populist know-how quite deliberately and unashamedly transferred from one populist authoritarian government to another. And so I think that this fact, which, as I say, is not seen as something embarrassing by both governments, but to the country, something that they can boast about, gives a special topicality, adds special actuality to my work on authoritarian populism. Let me start with some general points about my project and my work on these issues. First of all, my approach to populism. I don't want to spend much time on definitions of populism because it is one of the favorite pastimes of contemporary scholars and students of populism. Let me just make one point. I consider populism in purely institutional terms. So in the big divide in the scholarship on populism between those who identify populism as through its characteristic discourse or narrative, discourse which is based at the same time on various conspiracy theories and on exclusionary anti-pluralist approach, and on the other hand, on the other side of the divide, the institutionalist approach, scholars who are mainly interested in what populists in power, rather than before they get to power, do to institutions, to constitutional and other institutions of their state. I'm very much in the latter camp. So if someone protests, well, this is not really populism, I don't mind finding a better name for it. I'm interested in a particular phenomenon. Now, what does this phenomenon consist of? There are certain characteristics which are common to authoritarian populists all over the world, or at least of the sort that I'm interested in. And I think there are good reasons to be interested in it. The first point, the most fundamental, is they all can boast reasonably justifiably electoral democratic legitimacy. These are leaders, whether we are talking about Bolsonaro or Modi or Orban or Kaczynski, who have been elected in a by and large free and fair elections. Of course, by and large is a qualifying proviso, and there may be degrees of fairness and freedom of elections, but these are usually not elections in which an important electoral fraud, for example, was committed, or in which the opposition basically had no chances of meaningfully participating and winning the election, as in, say, Russia or Belarus, where elections are a farce. So the elections which led to our populist authority were not a farce. That's the first point. The second point is that they all, when they come to power, dismantle the traditional mechanisms of separation of powers or dispersion of power. That is, they monopolize all power in one hand, hence a very, very high degree of personalization of populist rule, and do it in such a way as to secure their powers, their re-election. Their re-election cannot be taken for granted. There is always a reasonable chance for the democratic opposition to win, but certainly there is no even playing field. They turn the institutions in such a way as to create strong assets for themselves for winning the election. The next point is that they all use this sort of, again, I refer to Professor Weiland's work, discriminatory legalism. That is, they use law, they do not dismantle legal institutions, they don't abolish institutions, but they use law and institutions in a very selective and biased way. That is, the law basically serves to protect they and themselves against legal penalties, say for corruption, and at the same time to harass their opponent, and in particular the opposition. So these are the main characteristics, the main sort of institutional characteristics of authoritarian populism, to which I would add just one other, and that is something that in political science and constitutional theory became known as quote unquote instantaneous democracy. That is the democracy in which the space between political will in the mind of the leader and the actual law in force is being shortened, in which various deliberate road bumps, which we know from democratic parliamentary systems, various forms of consultations, various forms of bargains and negotiations with the opposition, various forms of audits, multiple steps in legislative process, all this is eroded, and the idea for a law or policy becomes a reality as quickly as possibly it can be done. For instance, in Poland, my case study, there were times in which some very, very important laws entered into force, including the signature by the president, ratification by the president, in 24 hours. So we cannot talk about any significant deliberation. It is all being fast-tracked. And the more important a law is, the more fast-tracked it becomes. The next point that I would like to signal is that while I do realize that there are certain common characteristics for contemporary populist authoritarians, nevertheless, we should be talking about populisms in plural rather than populism singular. And there is certain intellectual laziness in talking about a populist wave in the world. All these cases of populism, even those which I mentioned, those 6 cases, and it's not a comprehensive list, it's just a list of countries I have selected as my case studies, are different. And the difference relate to different causes for populism, for populism's popularity in those countries. These causes differ, and they are always local. They always have something to do with local concerns, fears, worries of the citizens, to whom populists pretend that they can give quick and simple answers and provide remedies. And so, for example, in Poland, as I study what were the causes of the advancement and the emergence of popularity of the party called Law and Justice, PiS is Polish, PiS is Polish acronym, I see that they are not necessarily the same as those which gave popularity to Donald Trump or to Bolsonaro. They are different. There are different constellations and configurations of factors. And a very strong responsibility, scholarly responsibility of populism's students around the world is to identify specific configurations of factors in a given country which produce emergence and persistence of popularity of populist leaders. In Poland, in my view, these sources are not fundamentally economic or having to do with status anxiety, as was the case in the United States. They have to do with a combination of 3 factors: strong anti-elite approach, strong xenophobia, and strong anti-modernist nostalgia. And of course, if I had more time, I would develop all these points further. But now I would like to say something about 2 last issues which I have planned to raise during this introduction to a discussion here, and then I'd rather listen to your observations, comments, and questions than overburden you with my introductory remarks. So I would like to raise just 2 last final issues. One is about Putin's war against Ukraine and its impact upon populism in Central Europe, and the second, including in Poland, and the second is about the situation prior to the forthcoming elections in Poland in October 2023. So about Ukraine. I was in Ukraine a few days ago. Actually, last week I spent some days in Lviv in Ukraine and spoke to a number of people there, to a number of politicians and intellectuals, including academics from 2 main Lviv universities. And to those of you who read Polish and who may be subscribed to Gazeta Wyborcza, let me just advertise that my report from this visit will be published sometime next week. Now, what I have realized is that the impact of Putin's aggression has sort of two aspects which lead in two different directions concerning what its fallout or externality for Polish populism. For one thing, all those intellectuals and all my interlocutors in Ukraine, and there were many of them, very strongly draw a distinction between Poland and Hungary, which is fair enough, of course, considering how Polish government, as opposed to how Orban responded to Putin's aggression. But I think that it has very strong, this rift between Poland and Hungary, about which you all know, I'm sure, has affected adversely the early attempts of building in Europe some form of populist international. And of course, from my point of view, it's a very good thing. I mean, you may know that up to the invasion, up to 24th February 2022, two governments, Polish and government, acted in symbiosis, in some sort of synergy rather, to become an engine for patronage over various right-wing populist movements in Western Europe, in Italy, in Spain, and in France in particular. And that was a very, very worrying form of bolstering electoral chances of right-wing populism in Poland, including within the European Parliament, which in turn was used by Polish government as a huge, huge support for its actions. Now it's gone. I don't know for how long it's gone, but this Polish-Hungarian engine of supporting pro-Putin forces in Western Europe is extinguished for the time being. It's a good thing. But then there is another aspect which I would like to report from my conversations with my Ukrainian interlocutors. And that is that, of course, a very, very big part of the agenda of Democrats, of pro-Zelensky Ukrainians, which is basically everyone in Ukraine, is about joining the EU. And we know that it's not feasible as a matter of years, perhaps even decades. But it really doesn't matter when Ukraine will join the EU. It may take as much time as for Turkey. But the very idea of being a candidate and having the prospect of joining the EU is a tremendous mobilizing force. And now there is a problem, because Polish government presents itself as some sort of patron, as a bridge between Ukraine and the EU, as someone who advises and chaperones, so to speak, Ukraine on its road to the EU. But I ask my interlocutors, are you serious about having as your best ally in your attempts to join the EU, a government which in itself is in a deep, deep conflict with the EU, because arguably it is violating fundamental EU values, such as the rule of law and judicial independence? And they said, no, we don't want that. First of all, we don't want to have any advisor. We want to be treated as an equal partner rather than as a younger brother. And in particular, we don't want the authoritarian government of Poland to be our, so to speak, helper in joining the EU. So that is a very interesting point, I think, to consider. To what extent in this triangle, Poland, Ukraine, the European Union, how does it affect Polish credibility, which on the one hand, Polish government, I think, did all the right things when it comes to supporting Ukraine. I'm saying it as a credible critic of Polish government, but here I must, give credit where credit is due. Polish government acted properly and well towards the Ukraine situation. But on the other hand, it finds itself as being an outlier, almost a pariah in the European Union, and is being denied various funds, including the all-important recovery funds from the EU, based on rule of law conditionality in the European Union. So we have here a very fundamental problem. And the last minute, last 2 minutes, let me spend on the prospects for Polish elections later this year. The specific date has not been announced yet, but it should be sometime in October 2023. And short of unusual situation in which the government may try to postpone indefinitely the elections, which will happen only if it realizes that it's about to lose, and where it can use constitutional state of emergency, for example, based on the war on its eastern border. But I don't anticipate it will happen, because the chances of re-election for peace are unfortunately reasonably high. Then the election should take place in October, and the most frequent date being flagged by various observers and commentators is October 13th. At the moment, various opinion polls suggest almost 50-50. To be more specific, 40 in the most recent poll I have checked just before this conversation with you, Peace Plus Confederation, which is a new extreme, well, not new, an extreme right-wing party, which no doubt will form a coalition with Peace if Peace fails to establish independently its rule, is 45%. That's opinion polls of people declaring that they are going to go to polls, while combined number of all the democratic opposition parties, 4 main opposition parties, is 46%. So the difference is insignificant. It's not set in stone, it will change. It will change for sure. So we may say more or less 50-50, with today's declared turnout willingness of about 61%. But these 46% for combined democratic parties, that is Civic Platform, the Left, the Peasant Party, PSL, and Poland 2050, those 46% unfortunately translate into a strong minority in the parliament and into victory of peace, due to the type of proportional representation we have in Poland, where translating raw votes into seats in parliament gives a huge advantage to strong big parties and disadvantage to divided coalitions, okay? Disunited coalitions. And that's what you have in Poland now. So the chances of the electoral victory depend, as everywhere in the countries of weak democracy, whether we call it competitive authoritarianism or populist authoritarianism or electoral but not liberal democracy, etc., the chances for the democratic opposition to win fundamentally hinge upon 3 points. First, high turnout. Second, strong democratic coalition. Third, a credible program. When it comes to the turnout, obviously, and that I think is without any doubts for anyone, the higher the turnout, the more chances for the opposition to win, because it has more, if you like, assets it can mobilize among the undecided than a ruling party which has very strong mobilization, but that also means that they have very few people whom they may persuade to vote for them from the undecided. The second is the unity of the opposition. And here the situation is almost hopeless. When I was in Poland over the last 2 weeks, when I always also traveled to Ukraine, I was sort of like sick and tired with these ongoing debates about whether there should be a single coalition list or not. I'm happy to, or probably I'm not happy, but I will return to this point in the discussion if you wish. But the likelihood of a single list of the democratic opposition is now very, very low, despite a very clear preference of the electorates as opposed to the leaders of the opposition parties to have the democratic opposition run on a single list. And when it comes to the program of the opposition is basically anti-peace, is basically negative. And while this is a program I fully affirm and like, because I think that the last 8 years in Poland was an unmitigated disaster, and the rule of peace was unmitigated disaster and horror for Poland. Nevertheless, I think that no coalition can win only on a negative platform. It must produce a credible and emotionally beautiful, attractive program of its positive vision for Poland after 2023. Unfortunately, most of what the opposition is talking now is some forms of return. At least I have in mind the main opposition party, Civic Platform, is a return to pre-2015, and that will not mobilize democratic public opinion. Thank you very much, and now I'm looking forward to our discussion.
Thank you very much, Professor Sadurski, for that excellent general overview of populism, the wave of populism that the world is experiencing currently. I think it definitely very much helps provide a overall kind of background and explanation for what's specifically going on in Poland. But since this is technically an event sponsored by the Polish Club, and since you are first and foremost an expert on Polish politics, we're going to ask, I'm going to be asking specifically questions about the situation in Poland. So first, you mentioned how the EU has withheld post-COVID recovery funds, billions of euros in post-COVID recovery funds from Poland, specifically over rule of law concerns regarding the Polish government's undermining of the judiciary. And in response, the Polish parliament passed a law attempting to address the EU's concerns about Poland's judiciary. However, instead of signing the bill into law, President of Poland, Andrzej Duda, decided to refer the bill to the Constitutional Tribunal for review. And why is President Duda's action in this regard significant?
Well, it's significant because it's symptomatic for President Duda. I don't want to sound too harsh, but what he has done is an act of cowardly opportunism, of basically shifting the burden of decision upon a body which is a sham, facade body, and everyone knows it, including President Duda knows it. Polish Constitutional Tribunal is completely subordinated to the political will of the executive, mainly of the leader of Jarosław Kaczyński. No one seriously can, with a straight face, say that it is an independent court. So when President Duda, rather than either signing the law or vetoing it and sending back to the parliament, which may override his veto, both avenues, which would be at least at face value actions of an independent politician, takes the worst possible path and sends it to a sham body, sham institution. But these days, Constitutional Tribunal is even worse than sham because it's completely dysfunctional. It cannot even meet because some of these so-called judges contest the chairmanship of Chief Justice or President of Constitutional Tribunal. So it may take a very, very long time. And as an effect, presidential action is an action of indefinite postponement of this law. Now, the fate of this law may, but doesn't have to, predetermine the fate of those recovery funds about you are asking from the European Union. Whether the law about the Supreme Court, because that's the law in question, will meet so-called EU milestones is a matter on which lawyers are divided. I believe it will not. Others believe it will, but of course it doesn't matter what I believe or what other lawyers in Poland believe. What matters is what will lawyers for the European Union believe. But we will not know it before the law is being signed in force. Now, President even legally is disabled from signing this law because he must await the judgment of so-called Constitutional Tribunal, and it may take now weeks, months, perhaps years before the tribunal will decide.
You mentioned how there is a controversy in the Constitutional Tribunal, specifically over the Chief Justice of the Polish Constitutional Tribunal, Julia Przyłębska, and about 40% of the Constitutional Tribunal, 40% of the judges that sit on the Constitutional Tribunal claim that Chief Justice Przyłębska's term ended in 2022. However, the current Polish government and the remaining justices on the Constitutional Tribunal claim that her term ends in 2024. Why is there this controversy over something that should seem like over something like term length, which should theoretically be very clear?
Yeah, well, that's because of technicality. But before I address this specific point, let me say that some of those people who call themselves judges of Constitutional Tribunal, even under the textual express understanding of the Constitution, are not judges. We call them in Polish dubler, which is like a quasi-judge. I translate it as a quasi-judge because these are judges who have been in fact elected to the positions which were already filled by previous in previous parliamentary term, that is in November 2015. So there are three men on Constitutional Tribunal whose status as judges is about the same as, I don't know, status of drivers in the Constitutional Tribunal. Their judicial status about the same, with all respect to drivers who at least do an honest work in contrast to these people. But now, why is there this controversy? It's because of technicality. When Ms. Julia Przyłębska was elected and again, her election was full of irregularities, but I won't go into it now. I believe it was irregular. Her election as judge was fine, but her election as president of the court by the court itself was completely irregular. And I describe in my book why. But let me take for granted that she is president. Already at that stage, the new law on Constitutional Tribunal, which also provided for the term of president, was already enacted, but it still was not in force because there was this so-called vacatio legis, the time in which between the law being voted and signed and the law officially entered into force. So we have two legal interpretations. Some people say this law was already known, it had been discussed for a very long time, and it is generally accepted that the will of the legislator was to limit the term of office of president of the tribunal. And so this is the position taken by those putsch leaders within the Constitutional Tribunal. While president of the tribunal, Ms. Przyłębska, takes another opposite position, and she says, no, it doesn't matter that the law was already enacted, but it really entered into force literally few days after she was elected. So her term of office is governed by the previous law, which basically equated the term of office of the president to her or his term of office as judge of the Constitutional Tribunal. Well, as always, we have disagreement among lawyers. I do not take it too seriously because I believe that they all are no longer legitimate judges.
Yes, thank you, Professor Sadurski. You mentioned the concept of these quasi-judges, and various Polish and European courts have found that Poland's National Judicial Council, the body responsible for nominating judges, they found it illegitimate. And why? Can you please explain to the audience why these courts believe the council is illegitimate?
Yes. So National Council of Judiciary is a central and key constitutional and legal institution in Poland. This is something very characteristic for the continental European system and something which may be relatively obscure for lawyers or for people in the United States or say in the UK. But in Europe, in continental Europe, national councils of judiciary play enormously important role because they have the key role in appointments, promotions, and demotions of judges. So they basically decide about everything, the whole makeup of the judiciary in the country. And in Poland, judges, I don't mean constitutional judges, but regular judges play enormously important role, basically being now a countervailing force, putting strong resistance to the executive and legislative majority. So it is a standard in Europe that those councils of judiciary must consist at least in majority of judges themselves. So there are also non-judges, so that you cannot say that judges fully control the appointment process, but judges must have majority on the council. And that was the case in Poland until 2017, until the new law entered into force. We had a situation in which the 25-person council had 10 people who were non-judges, representatives of the Senate, of the Parliament, and the President, but 15, hence a majority, were judges. And they were elected by judges themselves in a very, very complex manner according to the quota. So different types of courts and different levels of courts had their quota on National Council of Judiciary. It was a system which began with the Round Table of 1989 and which persisted through to 2017. It was never contested. It was taken as a given. But here is a trick, or here's a catch, if you like. The Constitution says only, listing various members of the council, that there will be also 15 judges. But it fails to add 15 judges elected by judges. So, because it was just taken for granted. It's one of those cases of, if you like, constitutional omission or failure to make explicit certain things which are taken to be implicit. Because from the very beginning in democratic Poland after the fall of communism, it became part of the general understanding of constitutional convention that judges on the council must be elected by judges. And in my book, I provide a number of legal reasons for why this convention became binding. But when peace came to power, of course, it wanted to fully control judicial appointments. And so it said, well, if the Constitution doesn't say explicitly that those judges will be elected by judges, then yes, we will keep judges on the council because we cannot change the Constitution. We don't have sufficient majority. But we'll change the mode of their election. They will be now elected by the parliament. Elected by the parliament in the system in which peace has majority means de facto elected by peace. So we will elect judges according to our wills, and that's what happened. Under the law on National Council of Judiciary, all the judges elected by the parliament were nominees, friends of peace, and they conduct horrible work of the National Council of Judiciary, whose constitutional role is to protect judicial independence, became a very, I would say, invidious mechanism of harassing judges and of disciplining judges and of suspending judges who take decisions which are not liked by the government. So this is my response to you. It just shows something which goes well beyond the National Council of Judiciary itself. It just shows the attitude of populist authoritarians to constitution. For them, the text, mere text, is all that there is to the Constitution. There is no such thing as constitutional conventions or unwritten norms.
Thank you. Do you believe ideally that judges in Poland should be appointed by or nominated by other judges, the parliament, or like in America, nominated by the executive?
Well, look, as I said, every country has its different traditions and different structure of government. It also has different levels of political culture. It is no accident that European countries, I mean continental European countries, that is Europe minus the UK and Ireland, has opted for the system in which judges have a very strong, not exclusive, but very strong impact upon judicial appointments. It's a little bit more complicated than that, in fact. From the legal point of view, National Council of Judiciary in Poland, even in its ideal model, only makes recommendations to the president. So president still, and it happens occasionally, still may fail to act on a recommendation of the council. But okay, but the role of the council is all important. I believe that in those countries which went through periods of strong authoritarianism, whether fascism or Nazism or communism, or I don't know, models of authoritarianism as in Spain under Franco or Portugal under Salazar, have good reasons to be very, very reluctant to accept the dominant role of the executive in appointing judges. And that's what's different vis-a-vis the United Kingdom or the United States or Canada, in which on their territory, there was never a strongly oppressive, violent system. I don't want to idealize American democracy, but it hasn't seen anything similar to fascism or communism in its territory. So there are different traditions and there are different concerns. But all European states basically are what may be called transitional states. That is, states where democracy emerges from a transition from something much, much worse, from ancien regime, which was violent and oppressive. And that is why we Europeans have much more trust in judges themselves having a strong role in judicial appointments than entrusting the executives with this role.
Thank you. This will be my last question about the judiciary, just because there's so many different constitutional issues going on in Poland. But you mentioned how the National Judiciary Council is responsible for promoting judges. And recently, just a few weeks ago in Poland, there was a landmark case that just came down in which Justyna Wierzęcka, who provided abortion pills to a pregnant woman to help terminate her pregnancy. Justyna was convicted, and shortly after, in an opinion in which many people viewed as favorable to the government, current Polish government, because of their anti-abortion policies. And then very shortly afterwards, the judge who presided over the case was promoted. Do you think that it is inappropriate for the government to promote judges directly after deciding cases, especially ones that are seen to be favorable to the government?
Well, I think it's sufficient for you to articulate the question in such a way, which is a good articulation, to know the answer. Of course, it is completely inappropriate. And the case of Justyna Wierzęcka, which you have just described, actually illustrates in one instance at least two huge problems about the state of the rule of law in Poland. First of all, the way in which it is completely oppressive vis-a-vis women. In Poland, this sham constitutional tribunal, late in 2020, decided to render unlawful almost all abortion in Poland. Almost all. The only exception which it maintained was when a continued pregnancy is a threat to the life of a woman. But it counted in previous year for something like under 1% of all the abortions in Poland. The dominant huge number were abortions caused or motivated by genetic defects of the fetus, and they are now illegal. They are now unconstitutional. So the case of Wierzęcka shows how the government uses legal instruments to harass women in accordance with the stated will of the Catholic Church. They, meaning the government, was afraid of running this horrific law through the parliament, which it could because it has the requisite majority, but it was afraid of political cost of it. So it used constitutional tribunal, or whatever is left of it, to take this decision. And if you want to have a closer legal analysis of this decision, I had an extensive case note about a year ago in the European Constitutional Law Review about this judgment. But the second aspect, which your question illustrates, is about the control by the executive of judges. And indeed, this judge who had punished Wierzęcka under this law, and I emphasize simply for providing an abortion pill to another woman who asked her for it. She was immediately promoted, because it just shows that these promotions are fully at the discretion of Minister of Justice. And he can do it like that, overnight. And the mechanism for these promotions are that while formal promotion takes some time, and there must be some steps, including the recommendation by National Council of Judiciary, which now is not a problem for the minister for reasons we had discussed before, but still it takes time. He has a power of so-called delegation. So he can, quote unquote, delegate any judge anywhere in any court in Poland, and there are some 10,000 of judges in Poland, to a higher court without giving any reasons. For example, the minister may state that this other higher court has special human resources problems, so they need more judges. So he can, the Minister Ziobro, can sort of like shift judges from one court to another. Further, this power of delegation remains purely at the discretion of Minister of Justice under the new law of 2017. So at any time, the minister can demote a judge back to a court he or she came from. So yes, a short answer is this particular judge from Poznan, if I remember well, was clearly rewarded immediately for a judgment which the government favors, and the government favors this judgment because it acts under clear, strong, intensive pressure from the Catholic Church in Poland.
Thank you. Moving on now to freedom of speech. In Poland, many have claimed, including, well, even using your case as an example, that the Polish government is abusing defamation laws to silence critics. In addition, acts like offending religious feelings and offending public officials are crimes in Poland. Do you think Poland's freedom of speech laws should be more speech protective?
Oh, absolutely. Absolutely. And it's in many ways. First of all, we in Poland, when it comes to the criminal liability for offending public officials, we are still very much in the logic of the traditional medieval European crimen lege majestatis, that is the crime of offense of the majesty. While all, in other words, offending, say, the president or public officials is met with a tougher penalty than offending you and me, which is a reversal of a liberal democratic pyramid, where the higher in the structure of governance, the less protected against offense you are, as in New York Times v. Sullivan doctrine of the US Supreme Court, where, you know, if you accept higher positions, you must also tolerate a higher degree of your criticism, because you cannot distinguish between the offense and the political criticism. So yes, that's one aspect. Another aspect of it is that offending religious sensibility or sensitivity, I always confuse these two words, I don't know which translation would be better, is a criminal offense. And while it is not being used too often, the very fact that it's on the books creates a powerful silencing effect. It reduces the so-called breathing space for free and unrestrained discourse. And perhaps the most scandalous of all these things is the fact that defamation is not just a civil tort, but also a criminal offense. Article 212 of Criminal Code provides for criminal responsibility for criminal defamation, which, if done in public, may run you into 2 years jail. Now, I don't know of anyone who actually was sentenced to jail for criminal defamation, but again, it produces a tremendous chilling effect. And one of my numerous libel and defamation cases run against me by Polish government and by TVP was based on Article 212. So I was not just a civil defendant in other cases, I was also a criminal defendant. And I was so far, I was never punished. I've never lost any of these cases. But you can imagine what a tremendous and powerful chilling effect it produces. Yes, Polish legal state of affairs when it comes to freedom of speech leaves plenty to be desired.
Thank you. Regarding the separation of church and state, technically, according to Poland's constitution, the two are separate, but in reality, they are not. What can be done to strengthen the separation of church and state in Poland?
Well, this is both legal and political issue. Legally speaking, even the constitution provides for a special privilege for Polish Catholic Church as opposed to all other churches, because it says that its status is regulated by the Concordate Treaty between Poland and the Holy See. So it's not the case of any other church in Poland. So already there we have a constitutional privilege. But most of all, privileges of Polish Catholic Church are political and economic. I mean, there is an ongoing synergy, a sort of what I would consider to be dirty symbiosis between the church and the government of law and justice. The church fully supports this government, this party, doesn't even hide how biased and how pro-peace it is. So it is a huge asset for the ruling party in Poland that it can rely on full support of the church. And it's a huge asset because if some 80% of Poles still say that they go every Sunday to mass, it may be exaggerated, but still it's a huge number. Then you can see what a huge propaganda machine you get from the pulpit by priests every Sunday, including on the Sunday on the election day. And on the other hand, so this is a huge asset for peace. But on the other hand, this synergy is a huge, huge asset for the church, which gets not just legal privileges, which I have mentioned, not just gets its religious views enforced in law, as in abortion case, or as in bringing in religious teachings to public schools, but also incredibly high economic subsidies, which goes into millions. So in a sense, both sides, both parties to this synergy are happy, but we cannot talk about separation of church and religion in any meaningful way in Poland. No way, not even in a way in which countries which have formally established churches, such as the UK or Scandinavian states, where de facto the church stays apart from politics. In Poland, church is very, very much entrenched in Polish politics.
Thank you. At this point, I would like to ask if you'd be willing to take maybe one or two more questions, or if you'd prefer to conclude.
Now, I'm very happy to take questions.
Okay, excellent. Thank you. So regarding search and seizure, in early January of this year, a gynecologist's office was raided in Poland. Although prosecutors only sought one patient's files, Poland's Central Anti-Corruption Bureau's officers took all patients' files dating back to 1996. In addition, though prosecutors are expected to make copies of seized documents and return the originals to their owners as soon as possible, the prosecutors kept the original files for over 2 months. Do Poland's search and seizure protections need to be strengthened? Why or why not?
Well, of course, they need to be strengthened. Well, I must say I don't know the details of the specific case which you mentioned. But for me, the episode which you described is less about the legal status of search and seizure and much more about the uses or rather misuses of various law enforcement institutions in Poland, such as the one which you have just mentioned, which is basically a plainclothes police, which was meant to be used in mainly anti-terrorist activities, but de facto is used for harassing individuals who are seen to be somehow opponents to the regime. And the search and seizure and then keeping the documents indefinitely by this internal security branch, especially when it comes to medical records, is particularly horrific. It's inconsistent with the EU law. It's inconsistent with the European Convention of Human Rights. It's plain illegal. But these bodies, the internal security bodies, and there are numerous of them, anti-corruption body, the Bureau of Investigation, etc., are basically uncontrolled. The law adopted again by peace about internal security renders the actions of these bodies basically removed from judicial review. That is, there is a form of judicial oversight, but it's purely formal. Those bodies have to declare to the judges only statistics about, for example, their wiretapping or surveillance. They do not have to provide a judge with any details which would warrant such actions. So they are basically beyond any either political or judicial oversight.
Thank you. Now regarding electoral law, the current Polish government just revised its electoral laws to increase voter turnout, specifically of voter demographics favorable to them, such as rural populations and the elderly. However, the Polish opposition is claiming that it is unconstitutional to change the electoral code in the 6 months prior to an election. Were the current Polish government's actions in changing the electoral code so close to the upcoming elections unconstitutional? Why or why not?
Yeah, they are unconstitutional, although there is no textual requirement in the constitution itself. Nevertheless, that was a standard which was repeatedly established and re-established by constitutional tribunal in the period in which there existed constitutional tribunal in Poland, which I count until the end of 2016. So yes, there was a judicially imposed limit upon this temporal window within which changes to electoral law can be made, and an idea is that 6 months is minimum, better 1 year. And there are various, if you like, aspects of soft law in Europe, so-called best practices, etc., would say that the closer to the elections, the less discretion the parliament has in changing electoral law. And this law has been changed reasonably early, reasonably close to the anticipated electoral date. So for this very reason, it is already unconstitutional. Coming to the merits of the law, there are indeed many aspects of it which are cause for concern. And let's put to one side the official rhetoric of the government, because this is a deceitful rhetoric, that we simply want to have a higher turnout. In a way, Jarosław Kaczyński gave away the true reasons for changes in the electoral districts law, which come close to what would be called gerrymandering, by saying, well, let's have more polling stations in small villages so that people after the church on a Sunday can go to vote. So combine this, what I have said about the propaganda from the pulpit in the church. And since the electorate of Law and Justice is skewed in a way that it has most of its supporters in the countryside and in small towns, then obviously increasing the number of polling stations there may have a positive impact upon the vote for peace, for law and justice. But there are many other aspects of the law which may seem on the face of it completely innocuous. But when you probe into it, you see how they will disadvantage the opposition. Let me give you one small detail because it may be interesting for Polish citizens in the United States. So there is a new law, there is a new proviso about the electoral process on Polish ships abroad and abroad in consulates of Poland. Okay? And it is well known that in many, many countries, especially in the UK, where there was a huge wave of well-educated people, younger people, professionals emigrating from Poland when Poland joined the EU, but still before Brexit. So I think something like 70% of Polish diaspora in the UK is strongly anti-peace. And that is also the case in many other West European countries. I wouldn't venture to say what are the statistics in the United States. Now, the new law uses a very, very tiny detail, which not many people mention, and that is that all the commissions abroad, etc., have to formally inform the Central Electoral Commission in Poland about the results within 24 hours of closure of the polling station. What's a problem, someone will ask? Not a problem. Maybe it may be even seen as a proper protection against electoral fraud. You know, the more time you give to the commission, the more space it has for various monkey business, if I may use this word. However, in reality, the fact is that when combined with the new way of counting the votes by the commission after the closure of the commission, it turns out that for many foreign-based, many out of Poland electoral commissions, it will be simply completely impossible to complete the counting within 24 hours, because the number of votes they will have to count is much, much, much higher than for the commissions in Poland. But under the new rules, the count cannot be subdivided into like, okay, these three people will count those votes, you will count. They have all to be counted by the entire commission, so that the president of the commission picks up a ballot and says, this ballot is for this and this. Everyone can see, and then he or she moves to another ballot. It's impossible. There were already experiments, simulations made, for example, in London. It cannot be done, which de facto would mean disenfranchising a huge, huge section of foreign electorate. And, you know, with a big Polish diaspora and a very small margin between the two camps in these elections, a slogan is every vote counts. Indeed, every vote will count. It may be just a trick to disenfranchise the potential anti-peace voters.
Well, with that, I would like to thank you very much, Professor Sadurski, for your time, for sharing your incredible wisdom. Speaking for myself, no one has helped me understand the current political situation in Poland better than you. Thank you so much for everything you've done to advance the literature and information on the topic, especially regarding Poland's constitution and all the issues regarding it. I'm incredibly grateful for you joining us today.
Thank you very much, Mr. Silverstein. I'm very grateful for you for inviting me, and I hope for our ongoing future conversation on the matters.
Yes, of course. Well, thank you very much. Take care.
Thank you.
Thank you.